I'm Diederik from the Society of Advocates. I appear together with my colleagues, Advocate Amokoto and Advocate Linda of the Government Attorney for the applicant. Scott, please.
Together, the non-judicial colleagues Mr. Inquire and Mr. Bucas on the instructions of Metcalf, Bucas and attorneys for the first respondent.
Thank you, Mr. Shishimano. Mr. Inquire, thank you for introducing yourself. Yes, Mr. Introduction.
The presence in court explains the public importance of the matter presently in court. Your Lordship, will note that the first respondent filed answering papers.
I had barely chance to peruse them. Yes, I noticed.
Yes, within the time that was available for ourselves, we also briefly considered those papers, and we noticed that they also filed, the first respondent, a counter application.
I noticed so, yes.
And it would appear that the counter application is then also set down for today on an urgent basis, where they will seek Rule Nizai relief today. And I'll deal with that in a moment. Further, Your Lordship, given the time within which the answer was filed, the Minister did not, under the circumstances, file a replying affidavit.
Yes.
And let me briefly explain how that comes about. In the notice of motion, the applicant would ordinarily direct the time periods.
Yes.
It so happened that by inadvertent omission, the times for answer and reply were not specified in the notice of motion. And the only thing, and of course, fortunately or unfortunately, the first respondent took the benefit of that position, which I suppose it was entitled to do. What the notice of motion says on the second page, under paragraph A, is that, and I'm talking about this application and not the timeline set out for the Rule Nizai, which the applicant seeks.
Now, I understood it that they were called upon to file papers by now, basically.
It would appear that they understood it as,
Well, that's
this is a ex parte application by the applicant, and they had no notice because they can only file afterwards. And they do so in their answering papers, but of course that is clearly wrong. But the simple point I want to make, Your Lordship, was that because of this omission to say, you answer by then, we'll reply by then, and we'll be in court by then, as opposed to that conventional position, they had to answer, the court started now, 11:30.
Yes.
They had to answer before 11:29.
Yes.
Good. But
Theoretically, yes.
but unconventional, because we don't operate like that.
Yeah. But unfortunately, that's not what the notice of motion
That's
states.
what it is, Your Lordship. So we gave them that leeway, and they took advantage of it. So here we are. It's in that context, then, that the Minister does not file a reply. To the application, Your Lordship would note that what the Minister seeks on an urgent basis is a declarator pertaining to the conduct of the magistrates who are the members of the first respondent, and there are some 80-odd% of all the magistrates in the country. And secondly, that they be interdicted to continue partial stoppage. And let me explain how the Minister then comes to court.
Well, before you continue, is it your position that you don't want to file a replying affidavit?
Yes, Your Lordship, and I'll explain why also.
And you don't want to answer the counter application?
No, I'll deal with the counter application shortly, Your Lordship, and I'll
And you don't want to file heads of argument?
in respect of all the applications.
Well, yes, the first respondent did file heads of argument. Did you see that?
Now, maybe as Your Lordship walked
And it
in.
raises some serious, well, weighty issues.
Yes.
Amongst others, constitutional issues. The
Yes.
one being, of course, apart from the right to strike, which they contend for,
Yes.
the other probably more immediate issue is the locus standi of the applicant to come to court.
Yes.
I'm not going to hear argument on this without having proper heads of argument.
Then I
from you.
understand, Your Lordship, and I'll explain
Yes.
why there would be no need, and I'll demonstrate that shortly.
Well,
Why
I
there's
decide
no-
the locus point. I can give no relief unless I
I-
decide the locus point.
I accept that, Your Lordship, that is the position.
Yes.
The locus must be decided, because without that,
No, but
and
I'm not
in
going to
favor of the
decide it
applicant, there's
without,
nothing
I'm not
else.
going to decide it without heads of argument.
Yes.
Yes. Are you
I'll-
going to deliver heads of argument?
I'll explain to Your Lordship
Yes.
why a determination of the locus point is unnecessary. And I'll
Yes.
explain to Your Lordship why all the other points in limine raised by the first respondent is unnecessary to determine. And I'll explain to Your Lordship also and demonstrate why the counter application of the first respondent set down for today should be struck. I'll explain all that. So let me start with the main application
Yes.
and explain why Your Lordship need not determine locus and whatever else points
give
they're
relief.
raising. Yes.
I can give you relief without determining locus.
No.
Yes.
No, Your Lordship. So this application starts like this.
Yes.
The first respondent's lawyers and it's marked annexure D to the founding affidavit.
Yes. Mhm.
On 30 October tells the minister, you must gazette and you must do that, and if you don't do it, paragraph 13 of that letter, the partial stoppage. This is now if the minister doesn't act by 5 November, then the following will happen, they say. Partial stoppage of work will affect the commencement and continuation of civil trials and opposed motions in the Magistrates Court and criminal trials and bail applications in the Magistrates and the Regional Court across. And that inspires this application. And so the minister comes to court. And of course, Your Lordship could take judicial notice of the fact that it is widely publicized, the current so-called strike. Now, within the time available, and of course in discharge,
I don't know if I can take judicial notice of the extent to which there is a stoppage or not.
yes,
What is published in the media.
I accept that, Your Lordship.
No.
Yes,
I must deal with that as it's been dealt with.
as
in
it
the papers,
arises on the
in
papers. That's correct, I accept that. Now, so the minister, and we say, and I'll demonstrate why still the locus point need not be decided.
Yes.
In discharge of his constitutional duty comes to court in the interest of protecting the administration of justice. And he says so, and he says how he does it and why he does it and all that. Now, when this morning, around 8:30 or something, the respondents, first respondent, filed its answering papers. The following became apparent. And may I take Your Lordship to paragraph 84, and I'll refer to the other paragraph shortly. So we said, the minister said, by your conduct, you are contravening the code of conduct because you are harming the administration of justice. And that is the central theme that runs through the minister's application. And this is what the magistrates say. The applicant, that is the minister, does not provide any facts that could be a basis to allege that between 5 November and 11 November there was a countrywide halting of judicial business at the Magistrates Court.
You're reading from which paragraph?
That is 84, Your Lordship.
84 of the answering affidavit.
Of the answering affidavit. And the central theme that I'm demonstrate to the court is, and I'll read the other paragraphs, is that what the magistrates are saying this morning, and the deponent under oath on behalf of the magistrates, there is no strike. Paragraph 85, Your Lordship. And I make the point that if they're not striking, then the applicant does not need to be in court. Paragraph 85. Yes. I deny that even on the scanned facts put up by the applicant, there's any real proof of judicial work coming to a standstill between 5 November and 11 November. Paragraph 87. The first respondent took a stance, and that is the magistrates, that they would not stretch themselves and would carry out all their functions, that is, administrative work in the respect of courts, writing judgments, considering transcripts and submissions, attending court, solemnizing marriages, etc., only during the official hours of 8 a.m. to 5 p.m. And there's nothing illegal about this, 88. The magistrates have been attending their duty stations and carrying out their functions only during the prescribed working hours. So, on this version, and we understand, Your Lordship, that today we are in interim court, not in final court, and that the approach will be different and all that, but on this version, and considering the type of relief that the applicant seeks, he seeks to declare that there is a contravention of the Code of Conduct, and that there ought to be an interdict. And the Minister considers this morning what the magistrates say. We are working from 8 to 5. We are attending court business and we are doing everything. Now, on that disputed fact, when we one day get to return that the rule is granted, we know what the consequence will be. And in the interest of the administration of justice, the Minister adopts the following position. And Your Lordship, I make submission with reference not to evidence that is not before court, but with evidence that appears from the affidavit of the respondent. The Minister says, given that the magistrates deny that they are on strike, given that the magistrates say they are attending to court business, solemnizing marriages, writing judgments, doing admin work, and everything that is required of them during prescribed working hours, there is no need for me as a minister to seek an interdict and to seek a declarator. Because when I came to court, I came under a threat of, that is the 30 October letter. I came under threat of partial stoppage. Yes. And the magistrates do not say this morning in this affidavit, when did this happen? They don't say this happened today, happened yesterday. They don't say. But what we can accept for a fact. And depending on when the proceedings we are, today or what we can accept, Your Lordship, if the magistrates say that we are not doing anything unlawful, we are attending court business and doing all this, they're saying that there, the Minister says then, I don't require an interdict and I don't require a declarator. And it's in the context of that, then, Your Lordship, that I made earlier submission that there's no need to then determine anything about locus or incompetent relief or anything of the sort. Because had we known this through a letter, Your Lordship, this application was served on the respondent 2 days ago. Is that correct? 2 days ago, Your Lordship.
I hear what you say, but what do you make about the allegation 84 where they say the applicant does not provide any facts that could be a basis to allege that between 5 November and the 11th of November there was a countrywide halting of judicial business and magistrates courts. Now, we know what they threatened. You pointed that out to me. In
producing in this court. You're not really showing anything. You're exaggerating. But on our own version as a respondent, we are telling this court and the public and everyone that bothers to be interested in this that we, on our own version, we are working, attending court business, 8 to 5. I submit in those circumstances.
Are they saying with this, we've been doing that all along since 5
No,
November?
they don't. They don't say that, Your Lordship.
Yeah, they don't.
But when they say that today,
You accept that?
we must accept it.
Well,
And
probably, yeah. The issue is, of course, well,
And whether with respect, the veracity can be questioned or not, is a question for a different occasion. We will accept when they say,
I see.
we are not striking. The minister says, then I don't require relief because they're not striking, because they say so.
Yes.
So come Monday, we'll expect it is business as usual. In those circumstances, Your Lordship, accepting that the minister does not require the relief, and given where he came from, which inspired the application, I would submit that there'd be no cost consequence for the minister not pursuing this application.
I see.
May I also, Your Lordship, whilst I'm on my feet,
Yes.
address, and I just want to make one submission about the counter application. If you give me the counter application, I apologize. Yeah. Yeah. Okay. The counter application, Your Lordship, I apologize, there's no index and pagination.
I understand the circumstances of the application for court.
The first peculiar thing about the counter application is this. The respondent comes to court and he tells this court, and he tells the applicant, today I want a rule nisi. And today the court will tell you, Minister, when you must answer that rule nisi which I'm seeking today. It's conceptually disturbing.
And they also want interim relief in the meantime. They want
Yes, Your Lordship.
portions of that to operate as an interim order.
That's even worse. When they say, and on the interim relief, Your Lordship, they say,
But before you continue, I don't want to interrupt your flow of argument. They allege it's a conditional counter application. Now, I couldn't, in the little time available to me, gather what is it conditional upon. Do you know? Do you have any suspicions to make on that?
Your Lordship, I stayed up the whole night waiting for this application to come, and then I fell asleep, and then it didn't come. And it came this morning. So I didn't have time to consider that.
I see. Okay.
I see.
I'll ask Mr. Shiwan.
My attention has been drawn to the Lordship. It is here, and they're saying it's paragraph 141 of the. Is this the answering affidavit? 141 of the answering affidavit. No. Something doesn't become a conditional counter application just because you feel attaching that label. It must be conditional upon something.
Well, you have to, if you can bring a conditional counter application,
you
of course,
can.
but then you must say
You must
what
say.
it is conditional upon.
Yes,
Is it
conditional upon the rule being
main
issued.
application being granted,
Exactly.
for instance, in which case we then want a speedy resolution of issues and
Yes.
on that premise bring a conditional application
Yes,
or whatever, but at least it must be made clear
It must be
what
made
the
clear what the
conditions
condition is.
are, subject to which the application is brought.
Because if this is a blanket, I don't know what to call it, conditional counter on the basis of the main application succeeding, then they would be in trouble given the stance of the applicant in the main application. But, Your Lordship, that is not the... So we know that there's an unqualified, so-called conditional counter application. The notice of motion itself does not, as it would ordinarily do, qualify the condition. It doesn't do that. But my single submission as to why the counter application must be struck without further consideration is the following. You cannot come to court today and say, grant me interim relief, joining the Minister of Finance, Executive Director, and the Attorney General as 5, 6, 7, and 8 respondents, unless you demonstrate to the court. This counter application, I served on them. They have noticed that today I'll seek their joinder, because surely they have a right to speak and say whether or not they want to be joined. You can't be joined and then after the fact come and tell the court why they shouldn't have been joined. And then what? Unjoined. The non-service, we checked e-justice, Your Lordship, and unless I missed it, unless the application, counter application was served on the parties intended to be joined, there would be no basis for a consideration of the counter application. It must just be struck.
Well, what about notionally? I'm not saying it applies in this case, but notionally, say you would have persisted with your urgent application,
Yes.
And now you bring on the back of that a notional respondent brings a counter application, and there is now no time for the ordinary processes of application joinder and allowing everyone to exercise their procedural rights. What would be wrong, for instance, to bring a counter application with those parties already joined, although they're not part of the main application, file it, serve it, and say, well, confirm their joinder, for instance, in urgent circumstances, if it is urgent where we can dispense with the ordinary rules of court.
That's the ideal. They knew. We want the Minister of Finance, Executive Director, and the Attorney General as part of our counter application to deal with certain issues. We could simply have cited them, serve the application on them, and then ask in their condemnation for the non-compliance with Rule 40, with joinder rules. And then the court would exercise the discretion as to whether to condone the non-compliance. But then those parties are before court, they've seen the application, and they can speak.
I hear what you say.
The court must strike the counter application for another reason. The last paragraph on the notice of motion of the counter application say, if you want to oppose today's application, counter application, where we will seek interim relief, a rule nizai, then you will answer that application on the directions of timelines. It doesn't work that way. I must first answer, and then we argue whether or not you're entitled to interim relief on the basis of papers that are before court. You can't get the interim and then tell me the court will...
So what you're saying is no case for relief today, for instance.
Not at all, Your Lordship.
They should have afforded you more time to actually file your papers, and then we can have it. No, they're not entitled to a rule nizai with immediate effect today without affording
Absolutely.
your clients their proper procedural rights to file papers.
A classic violation of the worst kind of procedural fairness is this magistrate's counter application.
But on another dimension, if you're not moving your urgent application the way I understand it, the relief, what would be urgent about theirs?
That's why, Your Lordship, when my learned friend addresses Your Lordship on the counter, once I make out a case for urgency as the original applicant, a respondent with a counter application sort of like joins to the hip that urgency of the original applicant if the court condones the original applicant's application. But without that application, the respondent in any event, regardless of whether it's joined to the applicant, in any event must satisfy on its own the requirements of Rule 73.4.
Well, it's not always so that you can join at the hip.
No, depending on the circumstances.
That's no carte blanche to seek any kind of relief of any conceivable sort on an urgent basis simply because you file, there was an urgent application brought against you.
Yes, Your
Sometimes
Lordship.
and often it is so, but
Yes.
not
But not the
as an
default
absolute
position.
rule, certainly not.
So, certainly also because it might well be that arose yesterday. The respondent brings a counter application in respect of issue that arose 10 years ago.
Yes.
So
to
this
use
is
that
why
as an
that-
example to
yes.
to illustrate point, yeah.
So, regardless of whether they are joined by the HEAP as to the application that no longer is there, they must still convince this court that on Rule 73.4, they meet the requirements of A and B. They must still convince the court on that. And I'll wait for my learned friend to address the court. If he addresses the court on that particular issue, then we'll argue the urgency of the counter application only and reserve the right that if the court condones, that we reserve the right to answer that. And of course, if the court is not with us on the joint issue, to just strike the application for that reason. Those will be my submissions, Your Lordship.
Thank you, Mr. Shibana. You heard what Mr. Dietrich said, they are not moving their urgent relief. What makes your counter-application? Are you persisting with your counter-application in those circumstances?
Your Lordship, in relation to the conditional counter application, we deal with that at paragraph 146 and explain the condition. We deal with it at paragraph 146 of the affidavit and explain the condition on which the counter application, the conditional application is sought. That is, if the matter is urgent. My learned colleague Cindy hasn't read paragraph 146. But Your Lordship, we would there, if my learned colleague has,
I didn't read it, Mr. Chairman. I simply didn't have the time. I think I got to paragraph page 25, 26. And the rest I could really only scan through. There just wasn't time to thoroughly read it.
Indeed. Your Lordship, today is an interesting withdrawal. It's the first time you hear a party withdrawing a matter and attempting to argue the matter all in the same vein. And this is what we hear. We hear a proposition that, well, because we understand you to withdraw, to say that you are not on this partial stoppage as they perceive, which we know on their papers is scant. They say nothing that could establish any sort of stoppage. There are no facts. It is the worst way of pleading facts. That is, we find in the founding affidavit. And then trying to avoid costs. Our learned colleague then says, well, because of this proposition that there is the conduct of work, we are therefore withdrawing. Would say, Your Lordship, that this is an appropriate matter for the court to grant a costs order as against the first responder. Now, explain to the court why. And unfortunately, in the why part, I'll have to take the court to the facts that have rushed everyone here to court. We have been rushed to court by the first respondent on the proposition that they can establish, as they allege in their affidavit, that the courts have come to a standstill. When we pause and say, what are those facts? And we say, for example, they rely on reports. We'll take, for example, the first report, Okakarara, Annexure B. And it tells us that there are two magistrates, And I'd ask the court to go there just to demonstrate just how bad this application was and why costs should follow. And I'll ask the court to turn to the second page of the report dated 10 November 2025 related to Okakarara. We find there are two courts, Court A and B, and in relation to Magistrate Sakwasa, we find that, and this is what is said, upon his return, proceedings remained affected due to ongoing technical issues with the court's recording equipment, which has been non-functional for approximately 3 weeks. That's the problem. That's why Okakarara Court, nothing was happening. For 3 weeks, the court equipment is not functioning. And we go to the next magistrate, Magistrate Hasland. No trial proceedings were completed during the reporting period due to the non-functional recording machine and broader slowdown caused by the industrial action. But we pause. If there is non-functioning recording equipment, how can the court proceed? I'll give another example, Your Lordship, just to demonstrate just how bad this application was and why we say this application never should have been pursued as it was pursued. And I'll ask the very next report. It is for, it relates to a period 5 to 7 November, 10 November 2025 is the date. And
Is that the one,
Luderitz,
pertaining to Luderitz?
Luderitz,
Yes.
Luderitz, the very next one. And then we see point 1, Magistrate Chaka is sitting as a principal magistrate. Point 2, and this is important, I'll show you why this point 2 is important. Magistrate Dandoe as a relief magistrate for one case, that's what they say, is for one case, which has been set down for 5 to 7 November. But if we flip over, if we stop there and turn to point 5, the only time when we hear of some sort of issue, it's where the case of Magistrate Dandu for sentencing who did not travel due to the strike. And I'll show you that.
Sorry, you were reading from paragraph 5.
Paragraph 5, right? But Your Lordship must remember, they've already told, the report already says.
Which page of 5? I just wanted to be on the same page, literally. As
Yes,
you,
the first page of the report, paragraph 5.
the first page of the report.
Yes,
That is
for Luderitz. So we are told.
For Luderitz. There's a report. No, sorry, yes, this one is, yes, yeah, I see, I'm with you, yes.
So we are told, Your Lordship is told, and the first respondent is told, and anyone reading these papers is told, Magistrate Dandu is supposed to deal with one case, set down from 5 to 7 November. At point 5, the court is then told he is striking. If we turn over the page at point 8, the court will see 6 November, we started off court at 9 a.m., as usual, and it appeared the strike had ceased as Magistrate Dandu, the same magistrate who had one case, traveled from Kitmanzub for his case, which he finalized, the one case he had to finalize. And when the court goes through the reports, the court will find time and time again the same issue. This strike appears on these papers to be a figment of the imagination. And we say, simply because the papers are as bad as they are, the party who brings the application should pay the costs of those that had to rush to defend a Runaiza late at night. And Your Lordship, we then make the submission in the circumstances that even if one has regard to these reports, some are not signed. Luderitz is unsigned. Marientau is unsigned. Traffic Court 1 and 2 is unsigned. Betaini, they only attach one page.
Well, Marienthal, there, we do see on the second page that there were some stoppages. There's a wedding which wasn't solemnized, conducted, and then there was a Mr. Anderson who was in Marienthal for 5 November and started court, but around 12 o'clock informed the parties that he would not proceed further. He did not turn up on 6 and 7 November. Mrs. Kruger remanded the regional court cases late in the afternoon on those dates and things like that.
Indeed. So, Your Lordship, we're brought here because of allegedly one court, only one, if one goes through the papers. An unsigned report is the basis of that. No allegation that this there was any confirmation, a call to say, explain this report to me, to the prosecutor. So we simply say, Your Lordship, if we are right as we say that the papers demonstrate, and if one has regard to the fact that there's nothing said about an odd 26 courts, we know nothing is said about Okahanja, Rehoboth, Walvish Bay, Swakopmund, Ondangwa, Oshakati, Otavio, Ochuarongo, Tsumi. I could go on. 26 courts. There's only 7 courts mentioned, and of those 7 courts, only 1. Was there a reason for there to be Runaisi proceedings today in this court?
In other words, was there a reason for an urgent application at all?
At all. That's what we say. So we say what we have is our learned colleagues attempting to be clever, to avoid the problems that their poorly pleaded documents reflect, to avoid the problem of locus. And we say that with respect, the problem of locus is a constitutional problem. In all instances, Your Lordship would have said this would have even been an appropriate matter for this court to determine the constitutionality of the standing of the first responder, member of the executive, issuing instructions to judicial officers. But if Your Lordship agrees with us, finds that there ought not to have been an urgent application in the manner that it has been brought, then it must follow that the first respondent would have to pay the costs for the applicant would have to pay the cost for the first respondent. Your Lordship, in view of the withdrawal of the application, those will be our submissions, unless there's anything the court would want me to address further.
So I take it you're not persisting with your counter application, in other
Your
words.
Lordship, it was conditional on a finding of urgency. Once the withdrawal takes effect, there's no finding of urgency that can follow.
So there's no counter
So
application.
the condition is not met that we set out at page 146 of our affidavit.
There's no relief granted on an urgent basis,
There's
so
no relief
therefore
granted,
the need for your counter application falls away, you say.
Would accept that, my Lord.
Two legal considerations which weigh with me, and because it appears that at the moment we are only addressing costs. That's what we are addressing. You seeking costs for your opposition, and Mr. Diedrich submits that this is an appropriate case where I make no order as to costs. So, two legal considerations which weigh. The one is, in an urgent application, I'm not saying this one was urgent, I don't have to make such a finding, but in an application brought on an urgent basis, let's rather put it that way. As far as the merits are concerned, I must assume that the applicant's case is a good one. In assessing urgency. And whether an application is properly brought on an urgent basis. That's the one consideration. So I must hypothetically assume even the applicant had locus, so hypothetically, and even that the magistrates, he was entitled to bring an interdict because the magistrates were not allowed to strike, and further the requirements for interdictory relief and the like. I must assume that that exists. That's the one. The other one is, in assessing urgency, you don't apply the Webster versus Mitchell rule, which you're no doubt acquainted with. You apply Plaskin-Evans. You take the respondent's version on the facts. Your facts being on the urgency issue, no, it wasn't necessary for an urgent application. We didn't disrupt the work of the magistrates, or the magistracy. You make a particular denial. Mr. Diedrich has referred me to that in the papers. Hence the reason why they don't proceed, because you say, your clients say, that their magistrates are working. They are doing their work. That's probably the version I must accept, if it's pleaded well enough, and pleaded well enough in respect of the entire period, commencing with 5 November. It may be good enough for the latter part of that period, up to where we sit now, on the 14th of November. Was it good enough in respect of the first period? In other words, was the applicant, if he has locus, assume he has, entitled to move an urgent application in respect of what might have happened during the first part of that period, say as from 5 November onwards, and coupled with the threat that there was in that letter of 30 October that they will partially disrupt the work of the court. Address me please on these aspects.
Your Lordship, I'll start off by making the submission that the nature of the withdrawal is important. And the withdrawal is not just a withdrawal of the urgency, it is a withdrawal of the whole application. That means the assumption that would normally flow in determining the test for urgency does not find application. And we go to the general, where a party withdraws an application, it is accepted, deemed that the opponent was successful, and therefore usually costs follow. That's the general principle. So we would make the submission that at this stage, because we're not dealing with the question of urgency, we're dealing with the withdrawal of the entire application. The court should apply, were it to consider the question of costs, you should start off with the presumption, the general principle. The withdrawal means the first respondent has been successful in his opposition. That would be the first step. And then the next question would be, is there an exception to the general principle on the effect of a withdrawal and what it means? And we make the submission that there would be no exceptions in this instance. Why? Because in addition to saying that they are working, they say that we are refusing to work beyond our ordinary hours of work, and there is no illegality in that. Meaning, if we have to write a judgment for the day, that is what we are going to do, because we are not working beyond our ordinary hours of work. And that's what our learned colleagues ought to then in reply have. If they felt that that is wrong, they ought to then have said, well, there is still illegality, they don't. So we say, Your Lordship, there's no exception to the general principle.
You say simply the withdrawal of the application, or at least the relief was sought and none are now not moved, that justifies a cost order in your favor.
Indeed. Plus, as we have said, Your Lordship, that as a matter, when one looks at those facts that are placed before the court, effectively the court was rushed here because of a magistrate in Mariental postponing matters. And we know on Mayberg that when a court postpones matters, that's an exercise of judicial discretion. That decision can be challenged if the magistrate acted contrary to judicial principles or capriciously. And that's not the case we are here for. There are no facts that would attend to that. So as a matter of fact, we still persist, Your Lordship, that this would be an appropriate matter for there to be a cost order that follows the withdrawal. Indeed. As please the court, Madam.
Thank you, Mr. Chairman. Mr. Diedrichs, we are now only addressing costs. That's all that remains of this application. What are your submissions? You've heard what I've put to my learned friend, or your learned friend.
Yes. May I just get this?
You want the lectern?
There's a road to justice and a road to mockery of justice. Your Lordship would know that, to the extent that Your Lordship has read the answering papers, the first respondent makes no secret of the fact that they say those reports of the PG, of the Prosecutor General, they constitute inadmissible hearsay in these proceedings. The consequence? Ignore them. Now, Your Lordship is taken to the very same reports. They say the court must ignore. and they want to rely on what they label the inadmissible hearsay reports, and to use that as a basis to convince the court that it is a consideration for a cost order. It is with respect unconscionable. On the questions arising by the court, and before I come to that, in the context of cost, Your Lordship, a matter set down can be withdrawn in one or two ways. You get leave of court or you get consent of the other party. And whether it is giving it a name or not, what the applicant has done, it has simply demonstrated to the court why it does not pursue the relief. The only person in this court that says that the applicant has withdrawn the application and this is the consequence is the respondent. The court will determine itself what the cost consequence would be given the circumstance in which the minister's position arises to say, I no longer assert the relief which I principally sought. And for the purpose of cost, the issue must not be conflated. It is not a concession that was made, and call it a concession or call it this is the factual position on the ground, that we are working and we are attending to court business and all that. This is not something the minister knew before the application.
That is the crucial issue,
Yes, Your
which I
Lordship.
must determine.
A simple SMS when the application comes. Withdraw that application, we are working. Instead, they come with this belated, last-minute, convoluted application, 100 legal points, when, in fact, the crucial issue before this court that the minister pursued was the administration of justice.
Now, you postulated now the situation after the application came. What about before the application landed? During the period you prepared the application?
Yes, Your Lordship.
Decided to do it,
Yes.
prepare it and finalize it. During that period, what was the minister entitled to believe, or what did he know?
And that is I submit, Your Lordship, the crucial question for the purpose of cost.
Yes. I think
Because ultimately the question would be, was the minister warranted?
one of the more important ones.
The more important consideration, was the minister warranted to come to court? Not what does the PG's hearsay report say. Was the minister justified on the facts he knew at the time to come to court? This is what the minister knew. If you don't gazette Wednesday, we will stop and the courts will be slowed down. The minister can't sit back.
The threat in that letter.
The threat.
Yeah.
Minister can't sit back and pray and hope it doesn't happen. He must seek the assistance of the court. And he came to court to do exactly that. And when the magistrates now say, no, we had work, all is good, then that doesn't impact on the issue of cost as to why the minister came to court, Your Lordship.
Contents of the reports which the minister attaches to his affidavit. What do they, Mr. Chibana referred me to a few passages. What do the others, or what evidence is contained in those? I've read through them.
Just so, from what you read now, Your Lordship, I recall you read the non-functioning of the recording machine, and then he said, caused by the industrial action, and then he moved on.
Well, that is in the one report. There's a reference to the
Yes.
recording, the first report, the one of Okakarara.
I made you understand that he didn't say caused by the industrial action. Just get the report. I just want to see. What does the court make of the reports?
There are, what I saw in the reports, certainly aspects of, call it slow strike or work stoppage in certain instances, in certain respects. For instance, if you look at Marienthal,
Yes.
it's one. Paragraph 6 and 7 of the Marienthal report, there was a marriage which was not conducted, and then at 12 o'clock, there was apparently a magistrate who started court, and then at 12 he said he will not continue, and he did not turn up on 6 and 7 November. And maybe you can refer me to some others.
Your Lordship, there's also reports that speak of.
If you look at magistrates, there's a report here of, sorry to interrupt you, the next one, which is of 5 November, that appears to be traffic court number 1. There they say that there was a postponement, magistrate unavailable, busy with negotiations, lists a number of cases. I'm not sure, it appears to be the Windhoek traffic court, gathering from where the witnesses were from. Doesn't say it there.
That is the
Yes, traffic court Windhoek right at the end.
Yes, it's Windhoek.
Then there's a handwritten report which I can't decipher. Of course, it is probably hearsay, which doesn't mean it's inadmissible in urgent applications necessarily. But you know there are exceptions and there are qualifications to the exceptions and all the rest. But yeah, do you have anything to address me on as far as those reports are concerned?
And on that point, Your Lordship, as to the law on hearsay in urgent applications, it is quite permissible for the deponent, the minister in this case, to say, this report, for what it says, derives from that source, and I believe it. And once he says that, that satisfies the qualification as to the hearsay rule in urgent applications. And it does right in the beginning, Your Lordship, I think, right in the beginning, paragraph 2, save where indicated otherwise by the context, the statements herein contained fall within my personal knowledge and are true and correct. Where I refer to information not within my personal knowledge, I identify the source and verily believe such information is true and correct. That qualifies the hearsay objection. And then Your Lordship will also know that the minister says, I visited the courts. I sat there, I saw what is happening in Windhoek Court and Karatura Court, Magistrates Courts. Lordship, those will be my submissions. May I just get one quick instruction, Your Lordship? The minister wrote some further instructions that I just want to make sure. Is everything covered? Is it covered? Your Lordship, Scorpius, those will be my submissions. Thank you.
Mrs. Joanna, I don't know, he has argued cost, you've argued cost, he replied. Is there anything you still want to say?
My Lord, I would add nothing, say, for example, just to the reference to paragraph 19. Paragraph 19 is paused. It doesn't say, and we've criticized it in our affidavit, doesn't say when, which courts were visited, for how long, at what time. It's part of the difficulty with pleading to the affidavit, because there are absolutely no specifics. Beyond that, Your Lordship, we say we've said what we've had to say, and we still persist with our request for costs.
Thank you, Mr. Chair.
Indeed.
lastly, just to all parties, now the way things have turned out, we have an applicant who does not move its urgent application, and we have a respondent who doesn't move its counter application. No one formally withdraws, it seems, the applications, but they are not moved. They were also not argued. What would the appropriate order be I should make in respect of the applications? What comes to mind is I just remove them from the roll. Dismissing them, I don't think is the appropriate order.
Probably a removal.
Removal, I would think.
Yes,
Are you in agreement with that?
Yes,
That I just
yes,
remove them from the roll?
It would be a removal, and then the court would decide the issue of cost.
Yes, no, that I must
It
decide.
would be a removal.
That a removal, and then I determine costs based on the submissions you've made to me.
Correct, Your Lordship.
My lord.
That's all that remains for me to be determined is costs.
Yes, that's correct.
Well, yes, I'm going to consider your submissions on costs. I reserve judgment on costs. I will let you know my ruling on the costs in due course when it is ready. I will endeavour to deliver it before 15 December. If it's ready before that, I will let the parties know. I don't believe that any urgency pertains to the costs issue. So there's no rush, but my acting term ends by the 15th of December, and I would like to, as far as possible, finalise all my rulings and judgments before I go on, before my term ends. So, yes, that will then be the order. Judgment on costs is reserved until 15 December 2025. And then really, firstly, my order is both the application, the application in convention and the counter application. Those applications are removed from the roll of this court. Well, thank you, gentlemen, and lady, if that's all. I think that's the court's business for this morning. The court will then adjourn.